Supplementary cause list, pronouncement of judgment.
No merit, dismissed. Yes.
Item number 2. Any mention?
Yes.
Your Lordship, beg your Lordship indulgence. The matter item 5 and item number 6, Mr. Sen is there.
Item 5 of the main.
Of the main list.
Yes.
I'm praying for some accommodation, Your Lordship. This matter, to our knowledge, is under consideration before the Ministry, Your Lordship.
Item number 4.
5 and 6. I'm in item number 5. And Mr.
Item number 6.
Those matters, you said that.
Your Lordship.
On the illegal construction order first.
Unauthorized, not exactly illegal.
When shall we?
3 weeks, Lordship.
On the request of the parties, list of the 3 weeks. Both the matters, 5 and 6.
Obliged.
May I please, Your Lordship? I beg to mention item number 8, Your Lordship. I pray let the matter be taken up after 2 weeks, Your Lordship.
No objections, Your Lordship.
Yes. Item 8.
Yes, Your Lordship.
Here for the respondents.
Yes, Lordship.
You are objecting.
No objections.
2 weeks.
Yes.
2 weeks on the request.
Right.
Yes.
Your Lordship, I beg to mention item 14.
Item 14.
Yes, Lordship. I'm appearing for the respondent number 7, Your Lordship.
Perfect.
Your Lordship, I pray for some accommodation, Your Lordship.
Yes.
And for the petition, I've been informed just now, Manoj, that there's some difficulties, Manoj.
There is no difficulty here.
Yes, difficult.
This also at the request made on behalf of respond number
7.
7. List is matter after when?
2 weeks, Your Lordship.
Yes.
Oh, I'll you bridge.
May I please, Your Lordship?
Yes.
I beg to mention item number 11, Your Lordship. I pray this matter may come up after 3 weeks, Your Lordship.
Your Lordship, I'm for the respondent, Your Lordship. I have no objection, Your Lordship.
You have no objection.
No, Your Lordship.
Okay. 2 weeks on the at the request of the
Similar prayer for item number 12, Your Lordship.
You will visa other side.
Yes, my lord. I have no objection, my lord.
Same order.
Highly obliged, Lordship.
Yes.
Lordship, I beg to mention item number 10.
Yes.
Lordship, I pray for further 3 weeks, Lordship.
Yes, Mr. When? How long you want?
After 3 weeks, Lordship.
10. List after 3 weeks at the request of the London Council of the petition. Yes.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 4 of the daily list, Your Lordship.
Item 4.
Yes, Your Lordship. Your Lordship,
You're making a mention on behalf of?
Mr. VGK Kanta, Your Lordship. KHADC, Your Lordship. I think so. Your Lordship, there was a bereavement in the family, Your Lordship. That's why my senior counsel can't be here today.
Yes.
No objection. No.
You're applying for the private respondents. Just say the request has been made on behalf of Mr. VGK Kanta, London Senior Counsel, to adjourn the matter. Why? How long?
Your Lordship, 1 week, Your Lordship.
By 2 weeks. Yeah, Learned the petition. Stop. The petitioner has no objection. Prayer allowed. List of 2 weeks. Yes.
Obliged,
Keep
Your Lordship.
obliged.
Supplementary cause list. Item number 3.
So it's, this matter, there have been some developments. Well, we need some instructions. So I was praying if your lordships kindly grant us a week's time.
So on the request of the London Senior Counsel, list this matter on which date? After a week only.
After a week.
After a week.
Right.
Yes. This is a bail application.
Anticipatory bail application. If after this application was filed, some.
Court number 3 is not there today.
I'm sorry, my lords.
Court number 3 is not there today.
My lords, that's why it's come.
Item number 4.
May it please your lordship.
This is a writ petition.
Yes, my lord.
It has landed here.
Yes, my lord.
Unfortunately,
Unfortunately, everyone is recused, my lord.
very dangerous case.
No, very simple case, but there were other problems, my lord. Other problems. I'll just take a few minutes, my lord. Petitioner in this case, my lord, is a member of the MCS, and petitioner, my lord, is aggrieved by a gradation list that has been published by the government. I'll take a few minutes just to explain the exact nature of the grievance. If lordship kindly looks at page 25, my lord.
Yes.
Page 25, my lord. This is a notification of 7th September 2010. And
Yes, please.
And my lord, it is through this notification that the petitioner was selected into the service, my lord. So this, my lord, is a merit list. If I'm allowed to point to serial number 29,
Yes.
is the petitioner in the first item, my lord. That is Bantimon Blah. Serial 29.
Is a petition.
Yes, my lord. And also, my lord, if I'm permitted, just for convenience and just to enable me to explain the case better, if I'm allowed to point to serial number 34. Serial number 34, my lord, is the first private respondent number 3.
There are private respondents.
Yes, my lord.
How many are there? How many of them are there?
About 5, 6, my lord. Number 39, number 34, sorry, is the respondent number 3. So, my lord, this is a merit list. Petitioner in 2010 was above respondent 3 in the merit list. Subsequently, my lord, next page, page 27. Page 27, my lord, is again a notification of 2012. Through this notification, my lord, petitioner was appointed, received her appointment into the MCS junior grade, my lord. This was in 2012.
This declaration of result in 2010.
10, my lord.
This select list does not have any validity.
It was extended from time to time, my lord. There's no problem about that. Yes. So the petitioner, my lord, was appointed only in 2012. Prior to that, in 2010 itself, the respondent number 3, my lord, she had received her appointment.
That means the 34, serial
34,
number 34.
serial number 34, respondent number 3.
So the person below
had received
in the merit list was given appointment earlier than.
Yes, ma'am. That is for the reason, lordship will be aware that selection is one thing. Selection is dependent on merit and my performance in the exam. Appointment is something else which is dependent, I would say, on the reservation policy. So possibly on account of the operation of the reservation policy at that time, Respondent 3.
What about the reason?
Yes, madam.
That
Yes.
she was appointed before you.
In 2010,
But then the fact remains your name figured in the same merit.
in the same merit
So you
list.
were higher.
I was higher. I was senior. This was 2012. I received my appointment, my lord. Lordship may turn the page, my lord, 28.
Where is your name here in page
Yes,
27?
yes, my lord. 27, my lord. I'm number 1. I'm the first name. Now, page 28, my lord. Next page. Page 28, my lord, is a gradation list that was published in 2014. If I'm allowed to just point to the first line, the provisional gradation list of the members of the Meghalaya Civil Service as per Rule 16.4 of the MCS Rules 1975 is hereby published and circulated, etc. So this list, my lord, was published as per 16.
Provisional list.
That is
not a valid list.
Yes, it was in 2014. It was a provisional list. It was published under 16.4, my lord. Before I go to 16.4, if I'm allowed to point to page 40, my lord. Page 40. 40. Page.
Yes. Yes.
Page 40, my lord. Serial number 31.
Yes.
I am there. The petition is there. And on the same page, my lord, serial number.
This is the gradation list.
Yes, my lord.
Yes.
Serial number 36.
Yes.
Serial number 36 is the respondent number 3 I was pointing out, my lord. So the position or the hierarchy of the merit list was maintained in 2014. I was above respondent number 3, my lord. I say, my lord, I submit humbly, my lord, that this gradation list, as I had pointed out, was prepared in accordance with Rule 16.4. Now, Rule 16.4, my lord, is the fulcrum on which this entire case turns, my lord. If I'm allowed to place Rule 16.4. I'll just take a minute on Rule 16.4, my lord.
Yes.
Page 8 of this booklet, my lord.
Yes.
Page 8,
Yes.
at the bottom is Rule 16. Next page, my lord, is Rule 16.4.
Yes.
I'll read, my lord. The seniority of the members of the service recruited after the commencement of these rules shall be in the order in which their names appear in the list prepared under Sub-Rule 4 of Rule 6 or approved under Rule 8. Sub-Rule 4 of Rule 6, my lord, is the...
It appears to be more or less common in all the...
Absolutely. Absolutely.
Yes.
So this list, my lord, is the merit list. So provision is very clear, very simple, my lord. Seniority amongst the members would be as per the position in the merit list, my lord.
That is why your name appeared higher
Above,
than this.
above. So that is the reason, my lord, I was saying that the 2014 gradation list was in consonance, in accordance with the provision of the rules.
Seniority was maintained.
Yes, my lord. And moreover, my lord, it was also in conformity with the law that has been laid down from time to time by this honorable court itself. I'll just take a minute, my lord, page 44. Page 44.
44.
Yes, my lord.
Yes.
My lord, this is a judgment passed last year by Justice. Thank you. Here, the issue raised was a very similar issue. The petitioner claimed seniority on the basis of the date of appointment. So, petitioner was appointed prior to respondents. So, petitioner's case was that
That appears to be more or less settled. I don't think there is any dispute with regard to that.
I'm very happy that Lordship has expressed
Probably
Lordship.
unless I do not know if there is any other law.
Very well, my lord. But
That's what the understanding of the court also.
if I can take 30 seconds, my lord, on this one. So, here the
You
claim
can
was...
take all the time, you see, but then...
Yes, I'm very grateful. My lord, the contention, the claim of the petitioner was that I am senior because I was appointed prior in time, my lord. The court was asked to interpret a very similar rule to 16.4. This is 29(1)(b) of the Meghalaya Ministerial Service Rules. That is at page 51, my lord.
Yes.
Right at the bottom, my lord, 29(1)(b) has been extracted. Inter se seniority of the lower division assistants mentioned in clause B of sub-rule 1 of rule 3 shall be in the order in which their names appear in the result of the competitive exam, meaning merit list, conducted by the commission. Such lower division, it goes on. So here also 29(1)(b) was very clear that your seniority will be determined by your place on the list, that is the merit list. In that background, learned single judge, my lord, at para 12,
Yes.
at para 12, my lord, though it has been reiterated and held in various judgments that the date of entry into a service is the safest rule to follow while determining the inter se seniority between one employee or the other, however, in the circumstances such as the present case, where there is the presence of rules framed under Article 309 of the Constitution, which creates a distinction as provided in Rule 29(1)(b), the contention that the respondent 5, 6, and 7 were not born in the service cannot be accepted due to the presence of a specific rule. Moreover, the interpretation of the petitioner to bring in a date of formal appointment into Rule so-and-so cannot be accepted, as this factor is clearly not present in the rule. The judgments placed by the learned counsel for the petitioner are therefore of no assistance in the facts of the present case. So the petition was rejected. The writ petitioner's contention was rejected.
Because if there exists a specific rule,
Yes, my lord.
then that is what.
Yes, my lord.
In
Why?
absence of rule, definitely seniority will be given.
Yes, my lord. Why I'm spending some time on this is because this judgment was challenged before the division bench. My lord was a part of that division bench. If lordship looks at the next page, what my lord has said in the division bench, which was led at that time by retired Justice Banerjee,
Yes.
para 3, my lord.
Yes.
And this is of slight importance. Ordinarily, when recruitment for many positions in the same post is conducted through a competitive process, the persons who gain appointment at the end of the process are graded according to their merit. In other words, persons who obtain higher marks in the relevant competitive examination are placed higher in the gradation list as against persons who obtain lower marks. In many cases, rather erroneously, the gradation list is mixed up with the reservation list. This is significant, my lord, this observation. While the reservation list indicates how many of the recruits at a particular recruitment process would have to come from amongst the reserve categories, this is important, my lord, the gradation list prepared at the end of such recruitment process has no nexus with the roster and has to be prepared according to the inter se merit based on the marks of the candidate at the particular process, my lord. The writ appeal was also rejected, my lord. Writ appeal was rejected, rightly rejected, I would humbly submit. What is important, my lord, is the stand of the state in these proceedings. The stand of the state, my lord, is reflected in page 50, if I'm allowed, my lord, 49.
Are you arguing for a dismissal?
No, because the state, what I'm trying to impress upon this honorable court is the state now should be stopped from taking a different stand because the stand is contained. That is at page 49, para 8, my lord. In brief, the arguments that have been advanced by the learned AAG, Shri so-and-so for the state respondents is confined to the fact that the service of the lower division assistant being governed by the rules by application of the same, the instant case is covered by 9(1) of the rules, as the petitioner and the respondent 5, 6, and 7 were appointed by way of direct recruitment from the same competitive examination, and as such, the inter se seniority was determined as per the merit list and by the application of rules so-and-so of the rules. Their stand is also
their rule, they are supporting it. So
absolutely, absolutely, my lord, absolutely. Now, so this was the position based on the position of law and the rules that 2014 gradation list was correctly prepared. I submit, my lord. Two more developments took place after that. Page 61, my lord.
Page
61, 61.
Yes.
This was a notification of 7th March 2022. Through this notification, my lord, I was promoted. Some of the other respondents were promoted, including respondent number 3. Next page, my lord.
Yes.
Another notification of promotion. Some other petitioners who are before my lord today were promoted. Some other respondents were also promoted. My promotion, my lord, was on 7th March 2022. First notification. I was promoted and respondent number 3 also, my lord, were promoted.
Serial number?
I am at 15, 1-5. But this is not as per seniority or anything. 1-5. And respondent 3 is number 1. Twinkle so-and-so.
It doesn't say it is in order of seniority.
Yes, my lord.
It doesn't say it is on order of seniority.
No, it's not in order of merit or anything, my lord.
So the appearance of not
Yes, my lord. So the promotion.
higher at the lower position does not have.
No,
doesn't
no,
make
no.
any-
So this does not reflect any gradation list or any seniority. The promotion, my lord, was to the senior grade, MCS senior grade. Subsequently, in page 66, my lord, 66.
These are all officiating promotion.
My lord.
Officiating promotion.
Yes, my lord.
Yes.
Page 66.
Yes.
This is where the problem came up. This was another gradation list published on 22nd August 2022. If I'm allowed to point to the first line, provisional gradation list of the members of the so-and-so as per rule 16.4. It claims to be based on 16.4. So if it is based on 16.4, it should maintain that seniority as per the merit list. Does it do that? It doesn't. Page 71 may be looked at. Serial 46, my lord. That is the petitioner. I am there.
You are 46. Yes.
46. And the respondent who I was pointing out is at serial 32, previous page, my lord.
Okay.
So the hierarchy or the seniority that was contained in the merit list, reproduced in the 2014 gradation list, has now been inversed, my lord. So this obviously was a little surprising. We preferred representations against this. Many representations, reminders, etc. Finally, my lord, a one-line cryptic reply has come. Last page, Annexure 11, my lord. Page 85. Page 85.
Yes.
I'll read, madam. With reference to your representation on the subject cited above, I am directed to inform you that the gradation list published on so-and-so is in continuation of the gradation list published in so-and-so in pursuance of the High Court judgment dated 10/2/2022. So there was a, very cryptic, doesn't really explain.
Where is that judgment?
Yes, my lord. Yes, my lord. So there was a judgment, my lord, in 2022 passed by Justice Banerjee. Single page.
No, I have.
Well.
Yes.
Yes.
Now, though this is only the motion stage, but if Lordship allows, this judgment, my lord, was passed in on 10th February 2022. Dates are important, my lord. 10th February 2022 was the judgment. Lordship had seen my promotion was a few days later on 7th March. 7th March 2022. That is page 61.
Yes, but then after this order.
After the order.
Yes.
After the order. So I will, if required, I'll substantiate how that promotion, that event which happened after the order, has changed the complexion of things, my lord. I'll just spend a few minutes on this Justice Banerjee's single bench judgment. This judgment, my lord, was, the petitioners were, there were three petitioners. Petitioners were three of the respondents who are before my lord today in these proceedings. And respondents in that case, in the earlier case, are today's petitioners, my lord.
You were a party there?
I was a party there. Now, in that case, my lord, the petitioners that time, today's respondents, three of them, had raised the issue of seniority, claiming seniority on the basis of date of appointment. So, if
were the petitioners therein were selected by the same selection process?
Yes, my lord. Yes,
they claimed seniority over you on the basis of the date of seniority.
Date of appointment, because as I had pointed out, they were appointed in 2010. I was appointed in 2012. First page itself, my lord, the question is formed. The only question which falls for consideration in this matter pertains to the inter se seniority between groups of persons in the Meghalaya Civil Service and the Meghalaya Police Service. The principal ground urged by the writ petitioners is that since the writ petitioners were appointed earlier in point of time than the private respondents herein, there can be no question of ascertaining any inter se seniority between the writ petitioner and private respondents. Now, this was the question, my lord. This was the challenge raised. Para 18, my lord. Para 18, I'll read, my lord. It is submitted by some of the respondents that the real issue pertains to the subsequent promotion that the 2010 recruits and 2012 recruits might be eligible to obtain. It is not clear as to how the promotion from the same post to the higher post in this case has to be determined, and the rules of the employer in such regard have to be adhered to. It is possible that the promotion is on merit cum seniority basis when a separate set of considerations will come into play than when promotion is on the seniority cum merit basis. Whatever may be the case, it can never be lost sight of that the 2010 recruits, which are the petitioners in the present case, came to be appointed in the post much earlier than the 2012 recruits and will always be regarded as senior to the 2012 recruits in the entry level post. This is crucial. In the entry level post. Full stop. As to how the seniority at the entry level post will determine the future promotion is an altogether different kettle of fish and is not the subject matter of the present discussion. So, two things, my lord. Firstly, seniority was held to lie with the petitioners in this case, but only as far as the entry level post is concerned. Justice Banerjee, while passing this judgment, was very clear. I am not talking, Mr. Justice Banerjee was not talking of promotions or what is to follow
This
after.
is not in contradiction of whatever has been held in the division bench judgment.
It is not. I would say it is not. On the first flush, it appears little anomalous because it appears to say something different from division bench judgment. But reading it carefully, my lord, reading it slowly, I submit humbly that it says more or less what the division bench judgment says. This judgment only says that the seniority of 2010 batch is there, but only as far as the entry level position is concerned, the junior grade MCS. Once there is promotion, I am not talking of that. Judgment is not talking of that. What happens after the promotion, in the sense how is seniority then to be calculated after the promotion? Judgment is not talking about that.
Your seniority list, which is under challenge here, it came after promotion?
After the promotion, yes. After the promotion, yes. It came after the promotion, and that is the reason, my lord, I was saying that the promotion.
So when it comes after promotion,
yes.
What is the provisions?
Yes, my lord. I'll just come to that in 10 seconds. If I'm just allowed to point to para 11 of this or 10 of this judgment, because this is where my case is actually. Para 10 of Justice Banerjee's judgment.
Yes.
Para 10. It transpires that in 2012 a seniority list was prepared, and in such list the persons recruited in the year 2010 and the persons recruited in the year 2012 were clubbed together for determination of inter se seniority among them. This was patently absurd and completely without any element of rationality or logic. It is elementary that an inter se seniority list assumes that all the persons in such list were appointed simultaneously, whether on the same date or in the course of the same exercise. A person who has been recruited or appointed earlier in point of time than another in the same post can never be equated with the person appointed later even to the same post. The very need for preparing an inter se seniority list arises upon a number of persons having been recruited to the same post simultaneously or by the same process. It bears repetition that if several candidates have been recruited or appointed to the same post on the same date or in course of the same exercise, only then would their inter se seniority need to be determined on the basis of criteria which are fixed therefore. What is the criteria, my lord? Next paragraph itself, Justice Banerjee refers to Rule 16.4. So what has been said is important. That if you're appointed to a particular post on the same date, then inter se seniority has to be determined as per some criteria. What is the only available criteria? 16.4. In this case, that's why I was saying promotion has changed the complexion of things. I received my promotion on the same day as some of the other respondents. Respondent 3, who had pointed out. We were appointed to MCS senior grade on the same date. As per this judgment, if your appointment is on the same date, then inter se seniority has to be determined by criteria. In other words,
the same date means you have been selected by the same selection process. But no, it is not the case that you were appointed on the same
date. Lordship, I would, with all respect, my lord, I would humbly beg to differ, because promotion also is considered to be as appointment.
Oh no, so far as the promotion only?
Yes. Okay. So I was promoted on the same day as respondent 3. In other words, I was appointed to the same post as MCS senior grade on the same date. If I am appointed as the same date following Justice Banerjee's dictum,
let them file affidavits.
I think so, because it will take some hearing is required on this matter.
No, this service method, you will have to appeal many things to this court.
Right.
So this court understanding is Very little.
We are here to render whatever assistance, my lord.
Lordship will have to determine, because what happened, Your Lordship, admittedly, they are the 2012 appointees. The private respondent herein are 2000 appointees. The private respondent herein, Your Lordship, in 2018, they have challenged the accreditation list because they were placed above them, Your Lordship. So, Your
That is what
Lordship,
has been referred just now. Has been
Lordship, yes. Now the question will arise: what happened, Your Lordship? Because then they file a representation.
What is the direction passed in that thing that is earlier round of litigation, which you were reading just now?
Your lordship. So the observation, what was held by learned single judge Justice Banerjee was, as far as entry level post is concerned, 2010 batch is senior to 2012 batch.
Or fresh before the single.
Para 22, my lord. Last para 22, entry level batch.
So that means the very gradation list which was prepared in 2012, that is illegal. 2014, it is illegal.
No, my lord.
That is not correct, not in accordance with law.
No, my lord. That could be one interpretation. I'll have to.
There seems to be many things.
There are minute things which have to be examined.
Back to the state, Your Lordship. The state decide the seniority on the basis of that judgment, Your Lordship. As of now, Your Lordship, I kindly appreciate, Your Lordship, they were private respondent in those writ petition. They are happy with the judgment.
So that is binding on them.
Yes, Your Lordship, they have attained its finality.
Our stand is, my lord, that judgment is not against us. In fact, if anything, it helps us, man. I'll explain when the time is right.
We will file our affidavit accordingly, Your Lordship, yes. Only for R1, R2, Your Lordship.
Yes, hard Mr. Sindal on it. Issue notice. Returnable in 3 weeks. Mr. Andy Shulai. Along with.
There are many batteries, Your Lordship.
Yes.
It is me against the bar association.
You appear for 1 and 2.
One.
Lordship, it's
Yes, Mr. Singhal.
Item number 10, my lord. As far as
it's a lead item, Your Lordship.
1.
4 is the
Let us
lead
just
item, Your
finish this
Lordship.
and then the petitioner shall take steps for service of notice upon resolution number 3 to
3 to 15, my lord. 15.
within 2 days.
Within 2 days.
List after 3 weeks.
4 to 13, Your Lordship.
Same order, my lord.
Only different counsel will have to assist.
You are appearing for 1, 2.
In all, Your Lordship, in all.
1 and 2.
1 and 2, Your Lordship. From 4 to 13, but
Item number 4 to 13.
Oh, yes.
Same order can be passed, my lord.
Same order.
Yes, ma'am.
same order. Only the name will myself.
You will be the leading counsel.
I know, Lordship, because
Anyway, just record in those matters.
Lordship, yes.
Please supply your name, then they will.
Apply, Your Lordship.
Grateful, ma'am. Obliged.
Item number 14.
see, like I said in this, see, accordingly the application is dismissed. Separate, there are two applications. Do not write these applications are dismissed.
Item number 15.
Lordship, by Lordship.
Yes.
Please, Your Lordship.
Wait, please, Your Lordship. Your Lordship, my conducting senior counsel, Mr. Vijay Kanta, Your Lordship,
Is in bereavement.
Yes, Your Lordship. Before respondent number 2 and 4, Your Lordship, 2 to 4.
My lords, here the only thing is respondent number 2 and 4, my lords, they are formal respondents because the order impugned, my lords, that is passed by the same Milim, that's respondent number 5.
That order has been passed on the basis of the order passed by the discouncil. So his presence will be required.
Well,
When
that
will
order
he
also is under challenge, my lord.
when will he be present?
Your Lordship, next week, Your Lordship.
Next week, give us a date when.
Your Lordship, I can't see the date specifically, Your Lordship. Your Lordship, by next week he'll be here for sure, Lordship. Everything will be done by this week only, Your Lordship. Today is a Friday, so Monday or Tuesday, Your Lordship.
Monday, Tuesday, I have some difficulty. I'll be out of station, my lord.
Could we have it on the 12th, my lords?
I'll have to go and drop my daughters, my lord.
12th, subject to Your Lordship's kind convenience.
12th, Wednesday.
My lords.
Wednesday is okay.
Okay, Your Lordship. Good.
Okay. Just say on the request of so and so. This thing for the district council. Okay. This is matter on 12th. Give it on 12th. Make sure we take it up. You see, like this has been urgent. There is an interim period here.
My lords, it is for consideration.
it.
My lords.
You desperate to get it. Or
My lords,
not-
this is
not
that
essential.
matter which Your Lordships have
If it is
dealt
not
with.
that essential, then we can.
No, my
should
lords,
not be-
it is essential.
things will get passed.
What had happened, my lords, this is that matter where Your Lordships had dealt with the matter sitting in division bench also. The matter was returned back to the learned single judge with the direction that all issues will be left open. Now, even from the earlier point of time, my lords, where the original order of the single judge was passed, there was a position that was maintained. There was a status quo that was maintained, my lords. That gets disturbed.
Oh, that is that some legislation. There was a
Lordships.
Yes.
Your Lordships would recollect, my lords, the Honorable the Chief Justice earlier had passed that order.
Error or something was there.
Lordships.
It was corrected. Then it was again
My lords.
withdrawn.
Now they say, my lords, that it would be Nongkhla only, but for all practical purposes, it will be read as Nongkhla Ringi.
Order has been passed.
Now, which way that part will be interpreted then? That
My lords,
part of the order.
it has to be, if the legislation says Nongkhla, my lords, it has to be Nongkhla. We cannot interpret a legislation, my lords. They say that the legislation is correct, it has to be Nongkhla, but it will be interpreted as Nongkhla Ringi.
So that is something beyond.
My lords.
Nongkhla ringing will not come within Nongkhla.
No, my lords.
How do we determine that?
My lords, because the original position is, my lords, that it was always Nongkhla. Ringi was never there.
So that will be, you will be referring to the factual aspect.
Lord, not factual, my lords, it is purely on the statute.
It is not for the lawmakers to take into consideration.
My lords, they've taken it to consideration, that's why they put it as Nongkhla. Now, once the lawmakers have written Nongkhla, my lords, I cannot read it as Nongkhla Ringi.
Let us see, these are all interesting issues. There appears to be some caveat. Let us discharge the caveats.
Lordship.
You are appearing for a cavator.
No.
What is your caveat? Okay. What is your caveat? What is the number of caveat? No, your caveat application is numbered as.
Claimed it was Nongkhla Ringi.
Is it you are appearing for?
The same one,
No, we are saying Nongkhla.
That is caveat 44. Ainam Maniksim.
Well,
That is your caveat.
well.
Do we have the repetition, the other repetition? This one, 149. We'll get both of these listed together only.
Appearing for the cavator submits that a copy of the connected writ petition has already been supplied.
This one, 149.
Submits that the cavator, just before you say, the cavator herein has been added as respondent number
5.
5 in the writ petition, and a copy of the writ petition has already been supplied to him. So the caveat, this caveat petition does, thus thereby stands discharged by allowing the cavator to oppose the motion. By affording an opportunity, not allowing, affording an opportunity to the cavator to oppose the motion.
Well, may I pray that the other connected writ petition, my lords, WPC number 114.
There seems to be, there is only one caveat, or there is any other caveat. There is only one. There is another caveat, 45.
For 5 and 6.
Same order. So here only see, there are how many caveats are here?
One caveat.
One caveat. He's been this thing arrayed as.
I'm appearing now for 5 and 6.
That is okay. We'll enter.
He'll be
but the caveat is
respond number 5, my lords.
5.
You are what?
Oh, I'm sorry, my lords. 6.
I'm fine.
The senior counsel appearing with a battery of lawyers also has a confusion.
My apologies.
That same order, only 6 here will be only one thing. Do not write to both the respondents. Okay, Mr. So and so appearing with the caveat submits that the caveat has been included as number 6 in the connected writ petition, and the copy of the writ petition has been supplied to him. Stop the caveat. The stands discharged by affording the caveator an opportunity to oppose the motion of the writ petition. Yes. The writ petition listed on 12th.
Well, may I pray that the connected writ petition WPC number 149 of 2024 be taken up together, my lords.
When it is coming up? The other one?
That is also likely to come up next week only, my lords.
So then, if you want, then we will place it on the same date. But then that date has to be verified. Then we will not have it on 12th.
We'll just verify it, my lords. We'll supply it to the
Then
court
we'll
master.
do one thing. At least let it come up for motion on 12th. Then we will see subsequently.
My lords.
So the request of sorry.
Obliged.
Yes.
Daily cause list, item number 1.
Lordship, my rejoinder is ready. I'll file it today.
Is it ready?
Yes,
You're
I
filing
have
it today?
already
Can you
supplied the
today?
copy to the respondent.
Is it a criminal writ petition?
Yes, Your Lordship.
They have challenged the order passed by the Lok Ayukt.
Order passed by?
Lok Ayukt.
Lok Ayukt. Okay. The learned counsel, Mr. Alice, learned counsel, I think for the petitioner submits that the rejoinder affidavit to the affidavit in opposition filed with the Sunward 2 will be filed during the course of the day.
I have already supplied to the respondent.
It's okay, there is no problem. Then when shall we list it?
Let it come for hearing, Your Lordship, after 2 weeks. Then in the meantime, he will file.
You are there, you are also?
Yes, Lordship. Respondent number 2.
You are the main contesting
Yes,
respondent.
Lordship.
State is not contesting.
No, Your Lordship, because that is
Okay, just then you say submitted by the as agreed to by the London Council. The London Council acting with the parties list this matter for a hearing after 2 weeks.
applied.
Obliged, Your Lordship.
Item number 2.
Yes.
You are still interested in this case?
Yes, sir.
Still interested?
Yes, sir.
Yes, Mr. Panthi, any difficulty? Any difficulty?
Lordship.
What is the difficulty?
Difficulties, Lordship. Some difficulties came, my lord, not in a position to take up the matter today, my lord. Actually, my lord, here, in fact, on the last occasion, submissions was made, my lord, that certain report was filed before the Honorable Division Bench, my lord, and suggestions were made. And there, my lord, there are few suggestions wherein it says that, my lord, the department will examine the feasibility and for creating helpline numbers. There are few, my lord. So, in that view of the matter, so this matter needs to be proceeded, my lord. Not cannot be disposed of on the basis of, my lord, what has been held
But
in
it's
the.
not covered by the
No, my lord.
division-wise decision.
This is what this is report filed in the state, sir.
Oh. Just a minute, Lordship.
This was the file. This is file. If it's been, sir.
I don't have this. I'll have to go through, your Lordship. What does it say, Lordship? Because I don't have a copy of it.
So you give him a copy?
Lordship.
Give me one copy.
When shall we have it then?
We will have some other day, your Lordship. Let me go through.
Yes, sir.
This also straight for the parties list after 2 weeks. Yes.
Oblige, Lordship.
Apply, your Lordship. You can.
I'll give a copy, sir. I'll
You're
give it to
also
you,
there.
Yes.
Item number 9.
Yes.
May it please Your Lordship. Your Lordship, on behalf of the conducting counsel, Mr. K.B. Upadhyay, he is not in, due to some personal difficulties, he is not in a position to appear before this honorable court. So on his behalf, I pray for 2 weeks' time, Your Lordship. Also, Your Lordship,
Yes.
regarding the written objection, we are yet to receive a...
My lord. It was ready.
There is a written objection supposed to file it.
My lord, I was given the liberty.
Anyway, he's asking for time, so we'll just give it like
My-
this. On the request of the no, but then it is to be filed, then it has to go through this thing. You cannot. If it is an objection, it will come in the form of affidavit, isn't it?
Yes, ma'am.
So it cannot be. It just cannot it hover like written argument and all. You cannot hand it over. Just on the request of the petitioner. This is better for 2 weeks.
Highly, Your Lordship.
Deeply honest.
Item number 13.